Good afternoon, good evening, good morning, wherever you may be listening to this podcast. This is Dr. Olu Asekun here. Welcome to another edition of our podcast. Please invite your family members, your friends, your colleagues, and let us start this journey together. Today, as usual, we'll be going over recent updates between last week and now, and thereafter we'll be going over questions. So if you have questions, just send them in as we proceed. As I said, we are going to start with the updates of what happened between last week and now. Between last week and now, a lot has happened in the immigration sector. A lot has happened between last week and now. One of the major updates is that the Department of State, they announced a plan to revise the immigrant visa form, that is from DS-250. So they want to update it. They want to add additional questions. They want to include new provisions. So if you are planning to apply for an immigrant visa, so you need to be on the lookout for that. Another update from last week is that if you have a pending adjustment of status and you apply for employment authorization and it was approved, you have the employment authorization card. If your adjustment application is denied and your employment authorization is revoked, now I believe effective, let me see the date. Yes, effective July 15, which was yesterday, effective July 15, E-Verify can now locate a revoked employment authorization. So what that means is that if your employment authorization is revoked, if your adjustment application is denied, and it is stated in the denial letter that your employment authorization is revoked, you want to avoid any employer that is participating in E-Verify, because right now E-Verify has been updated to include verification of revoked employment authorization. I'm not telling you to do anything illegal, but you have to be smart. You have to be wise. Where I come from, you say that half information is provided for the wise. So it is left for you it is now your decision, whatever you do with the information. So the information I'm providing to you is that revoked employment authorization can now be seen on E-Verify. So if I were you, I will avoid E-Verify employers. That's what I will do if I'm you, but it's left for you to do whatever you want with the information. The next update I want to mention, this may not necessarily be news, but is that the White House they have a new policy now that federally funded benefits should exclude undocumented immigrants. Federally funded benefits should exclude undocumented immigrants. And when we are talking about federally funded benefits, we are talking about things like a preschool program, food assistance, certain mental health problems, homelessness services, family planning, all those federally funded benefits. Now they are going to be checking for immigration status before they can allow you to benefit from all those federally funded benefits. They are going to be checking immigration status. So if you are undocumented and you have children in school, just make sure you don't apply for food assistance. Pack food for your children and let them take their food to school. Their lunch, let them take it to school so that they don't have to be providing information about legal status just because they want to eat. That is where we are right now in this country. But if you're in that situation, it is better to prepare your children's lunch from home. Let them take it to school, eat at school, and come back home, and not have to participate in the food in the school. Because now, in order to be able to eat those food in school, they have to provide their immigration status. Okay, the next update is that this is very, very disheartening for me, but it is what it is. There is a prayer that God will grant us the serenity to accept the things that we cannot change, the courage to change the things that we can, and the wisdom to know the difference between what we can change and what we cannot change. Unfortunately, one of those things we cannot change are some of these, what I consider, I'm trying to choose the right word now. Well, I think within my right, I can call it barbaric immigration policies. Because right now, there's a new ICE policy that says that immigration judges are mandated to deny bond to immigrants who entered the United States unlawfully. So it doesn't matter how good your case may be. It doesn't matter how powerful or how strong your benefit may be. According to this new ICE policy, once someone is detained, they cannot get a bond, irrespective of how long the immigration proceedings takes. They cannot get a bond. That is the new ICE policy. If you enter the United States IWI without visa, and for any reason you are detained, you cannot get a bond. That is the new policy. It's unfortunate, but that is the new policy. So even if you have a relief, even if you have a viable asylum policy, an asylum application, even if you have medical grant, whatever the issue is, you have to present your relief in detention. So that is what this policy means. No bond should be granted to anyone who entered the United States unlawfully. That is the new ICE policy. It's unfortunate, but like I said, it is what it is. That is the new ICE policy. I wish I could change it, but I do not have the power or the means or the authority to change it. That is the new ICE policy. The next thing that I want to mention is that thanks to the Big Beautiful Bill Act, is now BBBA, Big Beautiful Bill Act, that was signed into law by the president on July 4. Thanks to that bill, ICE is now, I think they've started accepting application. They are going to hire 10,000 additional agents. They are going to hire 10,000 new agents, and they are also going to double the beds at the detention facilities across the United States. In fact, they have allocated. I initially thought that it was $150 billion that was allocated for immigration enforcement under the Big Beautiful Act, but I think on Monday, we were informed that it was actually $170 billion over the next 4 years. $170 billion. And also, they have allocated 46 billion for border wall construction. Yeah, 46 billion for border wall construction. So they have a lot of money now. In the past, we used to say that, oh, they can't afford that. Oh, they can't afford this, they can't afford that. But now they can afford anything. $170 billion. That's a lot of money that's been allocated to ICE for all this enforcement. So now they are hiring 10,000 additional workers. They are doubling the beds that are in all the detention facilities. You see, the issue here is that they are not even doubling the detention facilities, but they are doubling the beds. So what that means is that people are going to be cramped up. So it's the same facility, but the beds are going to increase. So, yeah,
There's going to be a lot of diseases.
yeah. So now people they probably are going to introduce bunk beds, like
They already have them. Remember the one with the alligators in Florida? They
aha.
have a lot of bunk beds there.
So they are going to double the number of beds at the detention facilities across the
Wow.
United States.
I'm thinking maybe like four. No, I'm
Well,
thinking like 4 beds.
if you can do anything, if you can do anything to avoid being detained, honestly, it's not going to be easy for anyone who is detained going forward. I mean, it's going to be really, really problematic because there will be more diseases, there will be more. I mean, how do you cramp people? They're already cramped, but now they are doubling the number of beds without doubling the number of facilities. So, well, like I said, it is what it is. There is nothing we can do about that. I'm just giving you the information. So, well, what appears to be a good news, hopefully it will scale through. Uh, there seems to be a bipartisan effort to fix immigration law. So a bipartisan bill, a bipartisan immigration proposal was introduced in Congress this week. A bipartisan immigration proposal, but like right now it's just a proposal, so we don't know. I mean, mega, is it mega or MAGA? MAGA, Make America MAGA. Okay, MAGA seems to have a lot of influence on the president. So even if the bipartisan Congress passed an immigration bill, if MAGA put pressure on the president may not sign it. Even if MAGA put pressure on the House of Rep, that bill may not pass. For Senate, they will probably pass because those senators seems to be a little more mature than the disorganized members of the House of Rep. But right now, there is a bipartisan effort to fix immigration law. So they have introduced a bipartisan proposal at the Congress. So hopefully something good will come out of it. If this administration, this president really want to fix immigration, is in a better position more than any other person to fix it because right now the Republicans control the House of Rep, they control the Senate, and they control the presidency. So hopefully this bipartisan effort will work, but at least they have started that proposal. So we pray that it will work. Okay, we've been on for 15 minutes, so let's go into questions so that we will be able to answer a lot of questions today. Is that the first one? That it seems it's just a greeting. A blessed, happy day, Dr. Olu. God richly bless and keep you and your family. Amen. Thank you. Okay, the first question for today. If a U.S. citizen who is also a U.S. Navy files for citizenship for her father with a green card, how long does it take to obtain citizenship for the father? Well, in the citizen, generally, right now, under this new policy, citizenship application is getting faster, especially if it is filed electronically. They are inviting people right now for interview within 3 to 4 months. So right now, it is getting faster. Secondly, uh, when you are completing the application, there is a provision where you will indicate that you are in the military. So if you indicate that, I believe that they give them much priority. But if you don't indicate it in the application, you may be in the military, you may be in the Navy, there is no way they are going to know that. So, but when you are applying for citizenship, you have to select that option to give them that notice. And of course, it's going to be much faster. And like I said, even general citizenship for anyone who is not in the military is pretty fast now, especially if it is filed electronically. They are inviting them for interview within 3 to 4 months. And if it's a straightforward case, you can get your citizenship in 4 months. But if it's a complicated one, because right now they have also increased the screening for citizenship. Remember, the president promised to denaturalize a lot of people. So they are really looking into every case, every citizenship case. And funny enough, I've seen some citizenship application denied for what I considered frivolous reasons. For example, there was a guy, this person is not my client, but it was somebody that I know because the lawyer that represented him is a friend and colleague, and we discussed this case. This person, maybe out of ignorance, a Nigerian citizen, was just boasting. He told them during his citizenship interview that he was a prince, And along the line, the officer seems to pounce on that aspect. And when he realized that the questions were not going the way he expected, so he changed his tune that, he was no longer a prince, that he was just boasting that he wasn't a prince. But guess what? Long story short, that application was denied because American Constitution and American law does not allow what do you call this thing? Royalty, things like that, the way you do in the UK. For some people, for some citizens to have some status above others, maybe like a knight, somebody being appointed a knight.
Title, some type of title.
Yes, for somebody to have a kind of title. So those things are not allowed under American law because American law believes that everybody is equal. So they don't want somebody to have some superior title over others. So all those feudal laws, all those feudal system in the UK, it's a problem here. And because the guy called himself a prince, so the application was denied. So now he's filing an appeal. So I'm just pointing out all these little things. I mean, that is so stupid. Even if you are a prince, that was not relevant in the application process. But again, he was out of, ignorance. He cost himself citizenship because he claimed to be a prince. So all those things, we are providing all this information so that people will learn from other people's mistakes. That's why we are providing this thing. Not that I'm happy with what happened to the guy, but I'm sharing this so that my listeners will learn from all these little errors, little mistakes. This administration, they are looking for every opportunity to deny citizenship. They are looking for every loophole, every single mistake to deny citizenship. So don't voluntarily give them reason to deny it. Okay, next question, please.
Oh, this is a question. This one was sent before that one, but it's just long.
Okay, thank you. Okay, I came to the USA in January 2018 when I was 16 years old with an F2 visa. My dad is on F1 visa status and is maintaining his F1 status till today. My mommy came to the USA with visiting visa and later successfully changed her visiting visa to F1 visa here in the USA. She then filed for asylum for myself and my other siblings within 1 year that we came to the USA. My mommy and I was only referred to court when I turned 21 years, and we are to appear for our first master hearing in July 2026 next year. My other siblings are not referred to court because they are under 18 years as at then. Today, I am 22 years old. I completed my high school here and I just graduated from a university in the USA this year. Am I qualified to apply for the Dreamers Act? If yes, can I apply before my first court master hearing? Well, can you please help me check the status of DACA? Because to the best of my knowledge, I don't think the application is open. Yeah, the application for Dreamers is not open. Yeah, I remember a court blocked it. And ever since that time, we have not been able to do that. So the simple answer to your question is unfortunately no, you cannot, because a court blocked that Dreamers Act and claimed that the president who enacted it at the time, that was President Obama, that he lacked authority. Please, can you help me grab water, please? I thought I have one. Oh, I found it. Yes. Thank you. Yeah, it was that was the creation of President Obama,
Okay.
but they challenged it in court and it was stopped by court. That was the last thing I heard about Dreamers Act. I do know that those who are already on DACA, they can continue to renew it, but no new applications.
For as long as not, they don't let it expire or not more
Yes,
than 1 year.
they can continue to renew it for as long as they don't have criminal record and they do not allow it to lapse. Once it lapses or expires, they cannot renew it. And of course, once there's a criminal record, they also cannot renew it. Otherwise, they can continue to renew it, but no new application can be accepted. And besides, from this fact, this person is not even qualified for Dreamers Act, because for Dreamer, you have to have been here physically on June 15. Is it June 12 or June 15 of 2012? That was the day Obama announced it, and you must have been physically present here, I think since 2008, if I recollect correctly. So this person is not even eligible. It does not meet the requirement of Dreamers Act. And secondly, no new Dreamers application is being accepted because the court blocked it.
Just as an additional information, they are being accepted as first time, but they cannot approve them because of that injunction. So, yeah, they're
Yeah.
accepting them, but just putting them on hold. They're not approving them.
Okay, I was being told here that they are still accepting it, but they are not processing or approving them because of the injunction. But again, this fact pattern does not even meet the requirement of Dreamers Act, because this person came in 2016. So it does not meet the requirement of Dreamers Act. So next question, please. Thank you for all that you do, sir. Is a receipt notice also the same thing as an extension when you file for EAD renewal? My employer is not accepting receipt notice. Receipt notice is not an extension. There are automatic extension in some cases. There are conditions for automatic extension. Number one, for the automatic extension to apply, you must have applied for a renewal of your employment authorization before the expiration of the current one. A receipt notice can, if your employment authorization application is the first time application, a receipt notice cannot be an extension. That is not what the automatic extension is all about. The automatic extension only affects renewals, those who already have employment authorization and they are applying to renew it, and they file the renewal application before the expiration of the current employment authorization. Then that receipt notice, the 540 days will apply. So for the 540 days to apply, you need to show to your employer the original employment authorization card and the receipt notice confirming that you filed the application for extension before the expiration of the initial employment authorization card. So that is the condition. So if you meet that condition, then that receipt notice and the expired employment authorization card guarantee you that you'll be able to continue working. And if the employer refuses to accept that, that will be a violation of federal law. Next question, please.
He's been sending the question for the last 3 weeks, so he wants us to please address it today.
Okay, thank you. Hello, sir. My I-360 was approved and my priority date is 24th May 2024. Well, I don't know if this is I-360 employment based.
It's religious based.
Religious, okay.
Yes.
Okay, my I-360 was approved and my priority date is 24th May 2024. I filed I-485 by 1st November 2024 alongside employment authorization. My employment authorization was approved, but my I-485 application was administratively closed in April 2025 because my priority date is not yet available and my underlying R1 visa status will expire by October 2026. That's next year. What options do I have that will enable me not to accrue unauthorized stay and refile my I-485 application in case my priority is still not available by October 26? Note, I have maxed out 5 years validity. Okay. Yes, this is not a peculiar question. A lot of people are in this category. Let me say this. Every employment-based green card or every employment-based application, EB1, EB2, EB3, EB4, EB5, all employment-based application, both immigrant and non-immigrant, all of them requires, it is mandatory that an applicant must be maintaining legal status at all times. Therefore, until the visa becomes current and you are able to submit a new I-485 application for adjustment, you have to maintain legal status. Now, you still have over a year, October 2026, but if you start looking, when it is 6 months before the expiration, if visa is still not current, then you have to find a way to change your status to another non-immigrant status for at least 1 year. Because for R1, the maximum you can be on R1 is 5 years. However, if you stay out of the R category, the religious visa category, for a period of 1 year, you can actually come back to R status. So all you need to do is to get away for R status for at least 1 year. I use R status to include your family. So even if you are the principal, you are on R1, your family will be on R2 because it is the entire R category that is barred from staying on R status for more than 5 years at a stretch. But if you stay out of R status for at least 1 year, you can come back to R status after that. So how can you do that? You can find example. You can maybe apply to a Bible college, go for a 1 year program, change your status from R1 to F1, finish your 1 year program, apply for OPT, optional practical training, that will allow you to have a 1 year work authorization. Before the expiration of the 1 year, you can now go back to R1. While you are doing all of this, it is very, very likely that the visa will have been current. But even if it is not current, you have another chance of staying on R1 for another 5 years at a stretch. So that would be my recommendation. Next question, please.
Well, this person is asking for our number, so I posted it on the chat.
Okay. Okay, next question. Sir, I asked to submit a police report. Which police report do I need to submit for my asylum case? The statement I made at the police station or the investigation report after my statement? This is probably an asylum question, and then I'm trying to understand this. I asked to submit a police report. Which police report do I need to submit for my asylum case? Yeah, if it depends on your story. If you reported the case to the police, yeah, you apply for the police report from the police station. I believe that is what you need to submit. The police report will have the information of whatever complaint you made. So it is the police report. You apply for police report at the police station where you made the complaint. So I believe that is all you need to do. Next question, please. Good morning, sir. I'm a naturalized citizen with 2 minor kids. So I apply for N600 for them, waiting for the fingerprint appointment. But dad lives in Nigeria, but he is on a visit in the USA now. Can you please move it forward? I think there is more. We want to apply for their USA passport. The passport office said we have to submit their green card. Will USCIS use the kids' Nigerian passport as a means of identification for their fingerprints? Please move it forward. I think there is more. Fingerprint appointment. Oh yes. Since they don't have American passport, yes, you can use their green card and their Nigerian passport for the purpose of keeping the fingerprint appointment. Yes, you can also use their green card and your own certificate of citizenship, certificate of naturalization, and their own green card and their Nigerian passport to apply for their for their American passport. Yes, all those options are possible. Next question, please. Hello, doctor. Good afternoon. Thanks for the education you are providing. You're welcome. I filed marriage-based adjustment of status, but my wife has packed and left the marriage after we had argument. Can you please move it forward? Kindly advise what remedies I might have before interview date. Well, one thing we try to avoid on this podcast is case-specific questions, because case-specific questions will require more information. Because if I'm telling you something now, I'm just going to be guessing. I don't know how much evidence of commingling of asset you have between you and your wife. I don't have how long you have been married. Can you please go back to that question? This is even I-485 that is still pending. Oh, okay. Good afternoon, Doc. Hello, Doctor. I filed marriage-based AOS, but my wife has packed and left it. Oh. This is still a pending application.
Yes.
There's nothing you can do. You don't have any recourse. She is the petitioner. Once she is out of it, there's nothing you can do to save that adjustment application. However, again, I don't want to provide case-specific information with a guess. I don't want to guess about the facts. I mean, there are some things you may have other avenue, but I'm not sure if you are eligible, if you will be eligible for it or not. But the simple answer to your question, if you have a pending adjustment application that is based on marriage, if the petitioner, who is your spouse in this case, if the petitioner is no longer interested, there is no way you can get the application through. If they invite you for interview and she doesn't show up, the application will be denied. And even if she shows up, the fact that she has packed out and started living separately, that will also create a doubt about the relationship. So my best bet is that I think you will need a one-on-one consultation with an immigration lawyer. So that's all I will say on this matter. Next question, please. What are the prospects of the proposed Dignity Act? Well, this is the problem why I don't like mentioning issues that are still ongoing. I don't have an answer for you. I don't know. I mean, I stated at the beginning that there is a lot that we don't know. Even there is no guarantee that it will pass. There is no guarantee that even the House of Rep will pass it. There is no guarantee that the Senate will pass it. There is no guarantee that the president will sign it into law. So we really don't know. This is just speculation at this stage. All we know is that there is a proposal and they are working on it. Let me remind my listeners, if you recall, in 2021, when was the last Biden election? I think the election was 2020. Yeah, Biden was sworn in January 2021. Yes. So when Biden became president on January 2021, that very day, that January 20, he sent an immigration proposal to the Congress. At that time, the Democrats were controlling the House of Rep. I believe the speaker was Nancy Pelosi at the time. And were they also controlling I think they were also controlling the House of, they are also controlling the Senate at the time. And of course, they were controlling the presidency. So they sent, the president at the time, Biden, sent a proposal, immigration proposal to the Congress. A lot of people started calling me at that time, what do you think about this? What do you think about that? All I keep telling them was that we are going to wait until they pass something. I can't be speculating over something that has not been passed. They may have a provision in the proposal right now. By the time they pass it, it may become something else. They may end up not even passing it. And guess what? The entire first 2 years when the Democrats were in total control, they didn't pass it. They were unable to pass it into law. Until today, nothing passed. The same thing when George Bush was president, Republican president, he sent a proposal, immigration proposal to Congress. They debated it, they didn't pass it. When Obama was president, he promised to fix immigration. He sent proposal. They debated it, they didn't pass it. When Trump was there the first time, he promised to fix immigration. They never did. So this is just a proposal. So I can't really, I can't talk about any prospect. If they pass it into law, yes, that's when we will look at what is passed and then analyze it and then explain it. But for now, whatever is in the proposal is something that is not certain. It can still change tomorrow. So there's really no point wasting valuable time discussing something that may pass or may not pass. Hello, sir. Do you know if there are arrests in ICE checking appointment for people who enter through the border without any crime, but without any inspection? Well, I've only heard of one case, only one case. But like I said, that one case was even before this new policy. But right now, the new policy is that anyone who entered the United States without a visa, anyone who entered the United States unlawfully, if they are detained, there is no bond. That is the new policy. But will somebody be detained when they go for biometrics? I really still don't know how they are going to handle that. But I've heard of one case of somebody who went for his appointment and was detained. But I want to tell you, every case is different. Every case is different because this person was even detained before this new policy. So I really don't know how ICE is going to handle cases of those who are reporting. Right now, I don't know. I don't want to give you information that I'm not sure of. But if we acquire information about it along the line, you can be rest assured that I will come back on the podcast and provide the information. But as of right now, I really don't know what ICE will do when people show up for their appointment. Please remind me. I will ask Ayla that question because I may not know, other Ayla members may know. Next question, please. Hello, sir. My I-360 was approved with my priority date. Is it not the same question that I answered? I already answered this question. Oh, okay. This is a little different. Hold on. Hello, sir. My I-360 was approved with my priority date as 24th May 2024. I filed I-485 1st November 2024. However, my EB4 application was administratively closed because my priority date.
I don't know. Is there a second?
Where is it? But it's very close to the
the
question
same-
that I've
it's the same
answered.
as the other one.
Even if it is from a different person, I believe that my first answer covers the two. So let's go to the next question. Good evening, sir. Thank you for all you do. May God continue to bless you and your family. Amen. Thank you. Sir, I and my spouse was called for interview by USCIS on January 16, 2025. And after the interview, we were given 120 days for their decision. Since then, we did not hear from them. What can we do? Well, if it's been 120 days, that's 4 months. That's more than the time for adjudication. So you can submit a service request. Try to submit a service request. Usually when you submit a service request, they will tell you they will get back to you within 30 days. So if you try service request maybe multiple times, if it doesn't work, then let your wife, who is probably the US citizen, let him contact his congressman or congresswoman. Use what is called congressional intervention, because I believe that congressional intervention works. But let me say this. If you are going to use a congressional intervention, I will advise you, go to a Republican congressman. I have this experience of some of my clients that I advise to pursue congressional intervention. One of them went to this African American lady that Trump is attacking. Is it Crooked or is it Crooked? You know that there is this African American congresswoman that Donald Trump is attacking all the time, because of course she criticized Trump for all his policies and all of that. So Donald Trump has been attacking him and all of that.
Congresswoman?
Congresswoman. Yeah, I think something Crockett. Is that Crockett or something? I'm not 100% sure of the name, but I know it has to do with Crockett. Did you find her? Congressman, Congresswoman. So the point I'm making here, did you find it?
Jasmine Crockett?
Yes. Yes, Jasmine Crockett. Is it Crockett? Did I get it
Crockett,
right?
yeah.
Crockett, okay.
Yeah.
Yes. So one person went to her office. Guess what? Immigration told the congresswoman that they will get back to her. And they never did. They never did. So they are probably not going to attend to Democratic congressmen who are criticizing Donald Trump. I mean, we already know that this president is very, very, I mean, flimsy. I mean, this we have a president who will go after anybody for anything. I mean, you will expect the president to use some level of maturity and ignore certain people, but no, not our own president. Our president goes after everybody. So, and you know that there are some people, even though the president may not give them specific instruction, but they see these other people as the president's enemy. So, don't go to president's enemy in quote. If you need help under this administration, don't go to Democratic congressmen. I mean, I'm just being honest and brutally truthful with you. That is the truth.
Has called her low IQ,
Yes,
low life.
yes.
Oh my
So
goodness.
they have been going after each other. He's been going after Donald Trump. Donald Trump has been going after her. So all our requests to immigration, they are neglecting it.
Oh yeah, someone is saying here in the chat, Jasmine Crockett is her name.
Is what?
Yeah,
Jasmine Crockett.
they're providing the name on the chat.
Oh, okay, on the chat.
One of
Yes,
your
yes,
listeners.
yes. So the point I'm making, you have to apply some wisdom. So don't go to Democratic congressmen or congresswomen. They are not going to get anything done under this administration. So if I were you, I would go to a Republican congressman for assistance. Next question, please. Good afternoon, sir. Thanks for your good work. Thank you. I filed for VAWA a year ago. I want to file for divorce now. Could that affect my case? No, it doesn't. It doesn't affect your case. You can even file for divorce before you file VAWA. It doesn't affect your case. The only time a divorce will affect VAWA is if you did not file your VAWA before within 2 years after divorce. You can divorce and then file VAWA after. You can file VAWA and then file divorce after. However, if you divorce first, you must file your VAWA within 2 years. 2 years after divorce, you can no longer file VAWA. That's the only thing. But filing for divorce, after you have filed your VAWA doesn't affect anything. Next question, please. God bless you, sir, and thank you for all that you do. I came to the US through the visa lottery in 2014 with my 9-month-old son. 5 years later, I became a US citizen. Please move it. My son, who is now 11 years old, has a US passport. However, some people are saying he still needs a certificate of naturalization. Is this necessary? No, it's not necessary. He doesn't need certificate of naturalization. He can't even get one if he apply for one. The only thing he could have gotten is certificate of citizenship, not certificate of naturalization. Only you, as the father, could get certificate of naturalization. But since he already has a US passport, he doesn't really need the certificate of citizenship. Whatever certificate of citizenship we do, US passport will do. And if he needs to renew his US passport, the old passport will be enough evidence. However, if you want it for your record, there's nothing stopping you from applying. It's just that you will pay. It's not free. So you apply for certificate of citizenship. So that is N600, not certificate of naturalization. You cannot get that. You apply for certificate of citizenship. You have to prove that he's been living with you. You have to show evidence of living together. So that's all you need. But it's really optional. It's not something you need, in my opinion. American passport is enough evidence. But if you want to keep it, you can apply N600. You pay the fee, provide the evidence that he's been living with you, and they will send it to you. That's all I can say. Next question, please. Good morning, sir. As an active duty Marine, my wife got a 2-year green card a week ago. Can she file for her naturalization? Oh, yes. If you're active duty, yes. Because a spouse of an active duty military member, they are required to be a permanent resident for 1 day. 1 day. So since you got it since a week ago, that's more than 1 day. Yes, she can apply for naturalization. Yes. In the naturalization application, she will need to select that option that says that she's the spouse of someone in active military. Very important, because if she doesn't select that, they will deny it. But she should select the right box. Next question, please. Okay. Hey, Doc, can you travel while the decision of your N400 is pending under extended review? Thanks for everything you do, Doc. God bless you and inspire you. Amen. Yes. However, make sure that you don't have any criminal issue or any basically a criminal issue or complicated case. But after interview, while they are reviewing it, can you travel? Yes, you can safely travel. There's no problem about that. The only thing is that when they eventually approve it and you go for swearing in, they are going to give you a form. In that form, they will ask you, has anything changed since your interview? Have you traveled out of the US? Have you married? Have you divorced? Have you been convicted? Have you been arrested? All those questions, they have it. So you have to complete it and update the travel part and then list the country that you travel to. That's it. It doesn't affect the merit of your application. But make sure you don't have criminal record, because criminal record, that is something completely different. That has nothing to do with your application for citizenship, but it can lead to you being detained upon your re-entry, and they will charge you as an arriving alien. Next question, please. Good afternoon, sir. I'm a green card holder for over 30 years. I had a DUI. I got a probation before judgment, which has been completed over 11 years ago. Can I travel out of the US? Yes. The rule here, when it comes to criminal conviction, there are some specific timeline. When you become a permanent resident, the first 5 years, that is the period of admission, you cannot have criminal record within that first 5 years. That is when criminal record can lead to being arrested upon re-entry. That is when criminal record can be an issue. That is when you face the risk of being placed in removal proceedings. That first 5 years. Now, the other 5 years that is relevant, that is the 5 years immediately preceding your application for citizenship. In other words, if you apply for citizenship today, so they are going to ask for your history in the last 5 years, your residential history in the last 5 years. your employment history in the last 5 years. So they are going to look at your history in the last 5 years. However, there is another requirement when it comes to citizenship, which is good moral character. That one is different from the statutory 5 years non-commission of crime. That one, they can use a conviction record at any time, even including 30 years ago. They can use it at any time. But that does not affect your ability to travel in and out of the country, especially for a DUI offense. It doesn't affect your ability to travel in and out. It will only be an issue when you apply for naturalization. And even when it becomes an issue, the fact that this conviction has been over 11 years ago and the fact that you have been a permanent resident for over 30 years, those are what do you call it? Those are factors that will be considered in approving your citizenship application. But can you travel outside of the US? Yes, you can travel. Next question, please.
Okay, so this is part 12, that same question. So travel outside of the United States.
Without encountering problem at the port of entry, can I be denied entry? No, I already answered the question. Yeah. I mean, that's why I went into detail in explaining all the 5-year problem and all that. You remember that we once have 2 clients that applied for citizenship. One was convicted. The conviction was after the 5 years, initial 5 years. The other one was convicted of a lesser offense, but within the first 5 years. So the one that was convicted after the initial 5 years was approved for the citizenship. The other one was denied. It is because of that statutory first 5 years.
I remember.
Yeah. Okay. Hello, sir. Kudos to you and your team, sir. Thank you. I'm in the US, submitted I-140 NIW EB2, receipt January 18, 2023, Nebraska Center. Yet to receive approval. Is there anything to worry about? It's very unusual. This is January 2022. That's been 2.5 years. Is the processing time that long? Can you please check the processing time? Well, anything to worry about? No, it's not about worrying. It's just to know whether it is due for service request. Not that you have anything to worry about. Because the good thing is that visa is not even current in the first place. So, January 18, visa may be current. Yeah, visa may be current. Please check the processing time for Nebraska Service Center I-140 non-premium processing, and also
7.5 months. Yeah, it's over.
Yeah, it's much over. Can you also check visa bulletin? Yeah, I don't think I've ever seen I-140 that is that long. But check the visa bulletin. Yes. Yeah, as far as processing time is concerned, processing time for Nebraska Service Center is 7.5 months. So this has been over 2.5 years. So you need to do service request for that. But let me also see if visa is current, because if visa is current, then it means you can go ahead and submit I-485. Visa is current. Yeah, it should be current. It's because I know that we file I-485 for people with a later date. Yeah, visa is current. So yeah, just do a service request. This is not normal. Yeah, do a service request. They have gone beyond the processing time. So this is too much delay. Do a service request. And of course, like I said, visa is current. If you are still maintaining legal status, you might want to go ahead and submit your I-485. At least that will also give you an opportunity to apply for employment authorization. So, yes. That is too much time. Next question, please.
If they mean the I-140, they didn't say the I-45.
No, they didn't talk about I-485 because,
Yeah.
yeah, it was probably a standalone I-140.
Someone said here it's 2023, not 2022.
Yeah, 2023.
2023.
But
Yeah, January 2023. That's what he wrote there.
Yeah.
Yeah, visa is current.
I think when someone was talking, either you or him, they mentioned either one of you mentioned 2022, but it must have been a confusion.
Yeah, well, he wrote 2023, January 2023. Visa is current and is beyond processing time. So do a service request or just go ahead and submit your I-485 application for permanent resident if you are in status. Because remember, if you have been out of status, if you file the I-485, it will be denied. And if that's something you don't want to do at this time, because if your application get denied now, it's going to be accompanied by a notice to appear. You are going to be placed in removal proceedings. So if you have been out of status, don't even try it during this administration. Don't try it. Next question, please. Okay. Good day, sir. Can a son of an immigrant that is 19-year-old in the army file immediately for his father that already has a green card to become an American citizen? No, I don't think so. For a U.S. citizen to petition for anybody, you have to be 21. So you have to be an adult for the purpose of immigration. 18 is an adult for the purpose of voting, but it's not for the purpose of petition. For the purpose of petition, you have to be 21. Next question, please. Sir, does this federally funded program include WIC, Medicaid for undocumented immigrants? Yes. All federally funded program, yes. Next question. Good afternoon, sir. How long is FOA taking to get?
It depends on what type.
Well, there are different types of FOIA. So is this EOIR FOIA? Is it USCIS FOIA? Is it DHS FOIA? Is it CBP FOIA? Is it Department of State FOIA? I mean, different types of FOIA and timeline varies. So it depends on which one. The next question, if I decide to submit EB1, will it in any way affect the pending EB2? Thank you.
That was the second part of one from before.
Yeah, if it's eligible for EB1, one does not affect the other, especially if it is just I-140. The requirements are different and the processing are different. One does not affect the other. So if you are eligible for EB1, you can submit it. But if this question is from the same person, visa is already current, why would you want to go and submit a new application when visa is current? Except if you are fearful that EB2 may not be approved. But I can guarantee you that if you are not eligible for EB2, you are probably not going to be eligible for EB1, even though the requirements are not the same. In fact, I take that back. Somebody may be eligible for EB2 and not be eligible for EB1. And somebody may be eligible for EB1 and not be eligible for EB2. So I take that back. The requirements are completely different. The requirement of EB1 is for you to show that you are one of those tiny percentage who have reached the top of your profession, maybe the top 10% of your profession. Whereas EB2, you don't necessarily need to have reached the top of your profession. You only need to show that you have a skill that you are bringing to the table. And because of that skill that you are bringing to the table, you want the U.S. government to waive the requirement of labor certification and the requirement of job offer because it is self-petition. You want them to waive that requirement for you. So the requirements are completely different. Next question, please. Do you have any idea when the EB3 visa backlog for employment rest of the world will improve? Oh, nobody can tell you that, not even USCIS. Not even USCIS can do that. It is the Department of State that release the visa bulletin every year, every month. They are the one that release the visa bulletin, and the one for August has already been released on Monday. So they are the one that release it every month. Nobody can predict when it's going to move, whether it's going to move forward. Even USCIS themselves cannot do that. That is the role of the Department of State. But let me also tell you, the only thing I can tell you is the factors that affect it. Factors that affect it include how many petitions did they receive at any particular month. And when we are talking about petition, it is not only by USCIS. Petitions received by USCIS, petitions received at the various US embassies all around the world. I'm talking of immigrant visa applications because it is the Department of State that process immigrant visas. So they are the one that determines how many immigrant visas has been issued in a particular month. And then they also collect the information from the USCIS, how many green cards were approved in that particular month. So the month when they receive more applications, the visa bulletin is going to retrogress. The month where they receive less application, visa bulletin is going to progress. So that's the only thing I can tell you about the procedure or factors that affect it. But other than that, not even USCIS can tell you when it's going to move forward or backward, because it is the number of immigrant visa applications issued monthly at the US embassies all around the world, plus the number of green cards approved by USCIS on a monthly basis. Those are the factors that affect the movement, because they cannot approve more than the statutory allocation for the year. Next question. The man God has brought to bring succor to people like us. Okay, I think that's just a comment. Thank you. My question is, I have EAD advanced parole. I have no criminal record. Can I travel to Nigeria and be admitted back to the United States? Yes. However, the question didn't tell us what the application is based on. Because if the application is based on a family petition, you have to be sure that you are in good terms with your spouse when you are traveling. And of course, that is important. But if it is a self-petition, then there is no problem. If it is employment-based, you also need to let your employer be aware of your movement and your travel abroad. Other than that, yes, you can travel. Good day, sir. God bless you. Amen. This person has been calling me. Can you please help me send him the link to the podcast? Good afternoon, sir. God bless you. Amen. My son filed for me and my green card was approved in October 2024. I have no criminal record. Will I be safe if I travel out of the country for 4 months? Oh, yes, perfectly fine. There is no complication with that. You can travel safely and come back in 4 months. There is no problem with that at all. Next question. God bless you for everything you do, sir. Amen. How can one check his I-94 to know his record? To know his record there. And is it safe for someone? Thank you. Is it safe for someone to do that, especially one that has overstayed? Oh, yes, there's a way to check your I-94. You can check it on CBP. Can you post the CBP link?
The link?
Yes, the CBP link. Yeah, you go there, you check your I-94. Yes, you need to have your passport with you, the biometric page of your passport, because it will ask for your name, your date of birth, your passport number, the country that issue your passport, all those information you have to provide. But of course, it will tell you when you are admitted and when your I-94 expire. That is something that you can do online. You can do it in your own house. So there's really no issue with that. Next question, please.
Okay, now this is our pinned message. This one.
Yeah, okay. Hello, good day, sir. Thank you for the info you are providing. How can one thank you, you're welcome. How can one apply for EB2 NIW without having previous papers or dissertation? What other EBs will be optional? The person is a PhD student in the USA. Well, I'm going to advise you to go over our podcast on EB2. If you go to our YouTube channel, you will see we have multiple podcasts on EB2. So you will see the requirement and how to do it, because if you are not eligible, as I said, this administration is a different administration. Right now, if they deny anything, they are going to accompany it with NTA, notice to appear. So this is not a period to just file an application for filing's sake. You have to be sure that you are eligible. And like I said, go over our podcast, because we did a 1 hour podcast on EB2 NIW. So I think one of the title is obtaining green card as a self petition or something. Huh? So you can go to our YouTube channel, search it, obtaining, or even if you go on Google, Dr. Olu Asekun podcast on EB2 NIW, or just Google our or search our what is it called, our YouTube channel. I think one of the title is obtaining permanent resident as a self petition. So you will get all the information you need there. So you have to be sure that you understand the requirement. It is not enough to have a PhD. As I've said before, I know someone who has a PhD and applied, in fact, not even someone, multiple people who have PhDs and apply for EB2 and were denied. It's not about having a PhD. It's not about your education. Education is part of it, but that is not the sole requirement. The main requirement is, what are you bringing to the table? Whatever you are bringing to the table, how is it going to benefit the United States? And the benefit to the United States, is it going to be a national benefit, or is it something that is going to benefit only a portion or a fraction of the country? Why should we waive the requirement of labor certification for you? Also, for you to understand it, we also have another podcast on labor certification. You can also check our podcast on labor certification, because before any U.S. employer can hire a foreigner, they are required by law to offer the position to American citizens first. So that requirement, you are asking them to waive it for you. So the question is, why should they waive it for you? What are you bringing to the table that will warrant them to waive it for you? Why should they put your interest above the interest of American citizens? So that is the question you need to answer. So it's not only about having a PhD. Next question, please. Hello, attorney. Peace be with you. Amen. Please, can one travel with advance parole to Nigeria in this present time? Thanks and remain blessed. Yes, I think we have addressed that question. You can travel with advance parole for as long as you don't have criminal record, for as long as you put your house in order. I don't know how you got your advance parole. I don't know whether it is based on employment petition, or it is based on family petition, or any other petition. But the major obstacle to traveling is criminal record. Criminal record. I cannot say it enough. If you have criminal record, don't move near the airport. Otherwise, you aren't coming back to this place. They are going to detain you upon your arrival. So criminal record, criminal record, criminal record. If you
Or overstay.
Well, there's one of our listeners saying, remember, sir, that you told us that if we had an overstay case before, we can use advanced parole safety to travel. So if you want to,
Yes, that was when they announced the policies. Yes, that has not changed. I'm talking of those those who apply for their advanced parole, those who file their application when they are still in status. Yeah, when they are still in status. Yeah, maybe I've assumed a lot of things. Yeah, it's a good thing they call my attention to it. Yeah, thank you for calling my attention to it. Yes, I've assumed that whoever is talking about traveling but still, even for those who have overstayed, I remember the question about somebody who said his son petitioned for him. Yes, even if they overstay before that petition, they can travel with the green card. Those are not the category affected
with the green card, but not
with the green card, not with the advanced parole, with the green card. Once you have your green card, it doesn't matter whether you overstay before you get it or after you get it. But if it is advanced parole, that's when the issue of overstay comes in. Because even with the green card, if you have criminal record, you will still have problem coming back. So that is why it is important to explain the two. For travel permit and green card, if you have a criminal record, don't travel. It's as simple as that. For advanced parole, if you have criminal record, don't travel. If you have overstayed before you got your advanced parole, don't travel. I think that clarifies it.
Yes.
Thank you for bringing it to my
That
attention.
was Mr. Rashid Adeoshun.
Okay.
The
Yeah.
one that sent the message.
Yeah. Thank you for bringing it to my attention. I believe that my clarification will help. Okay. The next question. Good day, doctor. Thank you for all you are doing. Amen. Thank you too. A friend was arrested back in the 90s between 1993 and 1997 for no payment of traffic ticket, and she can't remember the date. Can that affect her N400? Well, I don't know if this person already have green card at that time, or was it after that time, because either way, it's not supposed to. But the reason why I need to clarify is the 5-year rule. That's why I need to clarify it. Because if the person got the green card after this incident, then it means that that issue has been resolved. Because the 5 years that we are talking about, the statutory 5 years for citizenship, it is 5 years after you become a permanent resident, not 5 years after you started living in the US. It's 5 years from the date of your green card. So if this person already have green card at the time, even this person is talking about arrest, the issue is not arrest, the issue is conviction. Arrest and conviction is not the same thing. Somebody may be arrested and then maybe discharged. The case may be dismissed. Arrest and conviction are not the same thing. This person keeps calling. Did you send? Maybe you send a message that I'm on live podcast.
I did. That's what I said.
Yeah.
I'll send it again.
I think I got distracted. What is it that was? Okay, I was explaining the 5 years. Yes, the 5 years is actually from the date of the green card. That is the statutory period for the purpose of citizenship, not 5 years from the date of living in the US. So if let's assume this is a conviction. If this conviction was before the green card, it will not matter at all. It will not matter at all because that issue will have been resolved at the point of green card. The 5-year statutory period for the purpose of citizenship is from the date of the green card, the first 5 years after becoming a permanent resident. That is how to calculate it. And let me also say this, like I said, arrest and conviction are not the same thing. Somebody may be arrested and then the case may be dismissed. That's not going to affect anything. But if it is a conviction, then the first 5 years from the date of the green card, that will affect citizenship. But if it is not a conviction, it doesn't affect it in any way. Next question. Good morning, sir. I got my green card dated for 2021, but my asylum was approved 2018. When am I supposed to apply for my citizenship? 5 years from the date of your green card. So if your green card was 2021, you have to look at the month, because you can actually apply 3 months before that 5 years, but you have to be a permanent resident for 5 years. That is the category of people who got a green card through asylum, 5 years. So if you got it 2021, 5 years after will probably be 22, 23, 24, 25, 26, 26. But it may be this 2025 depending on the month, because you can apply 3 months before. Next question, please. And I think we need to stop by 1:30.
You're almost done with the questions up until the time that we announced that we were going to.
Oh, okay, okay. Good afternoon, Dr. Asekun. Thank you for your selfless and sacrifice service to the immigration community and to all by extension. You're welcome. Please, how can I secure a direct consultation with you, sir?
We posted our information we pinned the message on top of this.
Okay. If you look at on this
On the chat.
on the chat, you will see our direct phone number. Please move to the next one.
We pinned it.
You can send a message directly to that person, maybe with the numbers.
We can't.
Okay. Post the number online. That's the cell phone, the office number.
No. We have a pinned message.
Okay. Well, I don't know. I'm not an IT person. I don't know how that works. But we have a pin message. Maybe they will understand that.
See right here, like how this one is like there, and it doesn't move. That's the one with our numbers. That's a pinned message.
Okay. I hope whoever sent the question understand that. They said we have a pin message. I don't know how that works, but
We can just look for our website.
or just go to our website, oluasekun.lawyer. Simple as that. Our website is oluasekun.lawyer. Next question, please. Hello, sir. Thank you for your help. Please, how can I withdraw my asylum case after getting my green card through marriage? Send a letter to the asylum office, attach a copy of your green card, attach a copy of the receipt notice for your asylum, send it to them. It is possible that it will have been terminated upon your green card, but just to be on the safe side, send a letter of withdrawal, official letter of withdrawal, send it to them, attach a copy of the receipt notice for the asylum so that they will be able to trace it, and then attach a copy of your green card to show that you are now a permanent resident. Next question, please. Sir, is it safe to request for FOIA, or should let an attorney request for you with recent atmosphere in the country? It doesn't really make any difference, because for you to request a FOIA, you still have to provide your identity. So whether you are doing it through an attorney or you are doing it through yourself, by yourself, you still have to provide your identity. So if your fear is not providing them with your information, then you are not going to get your FOIA. So it doesn't really matter. It's the same thing. Can you please move forward?
That's the last one.
That's the last one.
Okay. Okay. Yeah, I think we are going to have to stop here today. Thank you for listening. We hope to continue again next week. We know that we are in a very, very difficult time right now, but I'm very, very optimistic. I'm hopeful. I know that when things are hard, I mean, something good is about to happen. I pray that this proposal in the Congress will actually work. We pray that those who are in charge, God will speak to them and they will probably be able to do something about immigration, and everybody, especially people who are already here, people will be able to move freely and do things freely. In the meantime, please avoid anything at all that can bring you to detention, anything at all. And when I say anything, I mean anything. From my experience, a lot of people get into trouble because of drinking, because of alcohol. From time to time, I see cases of DWI. I see cases of public intoxication. If you must drink, please buy the drink and drink in your own house. Buy it and drink in your own house. You don't necessarily have to drive. If you drink in the public, you can still be arrested. You can still be charged for public intoxication. It is not only people who drink and drive who are being arrested. I know someone who drank and was sitting down in his own car without driving in a parking lot, and this person was still arrested for public intoxication because the police officer or the security officer in the parking lot noticed that this person has been sitting in the car for hours, and they were concerned about the person because unfortunately the engine was running. So the person called the cops. So the cops came, and of course they noticed that alcohol was smelling. Long story short, the person was arrested for public intoxication. So please, I'm not saying don't drink. You can drink if you want, but drink in your own house. Don't drink in public. Don't drink and drive. Avoid all those little things. No matter how bad the system is, you have a role to play. So play your part and let God play his own part. Until next week, hope to continue. I remain Dr. Olu Asekun.